Welcome back to Courtroom Chronicles, where real cases unfold and the stakes couldn't be higher. Today's hearing is anything but routine. We open with Michelle Laws, a woman already on thin ice, on probation for child endangerment, a state jail felony. But things have spiraled. The court alleges violations from missing curfews to searching for drugs, all while battling mental health challenges. Her attorney throws a legal Hail Mary: hold off on incarceration and give her one last chance at a 30-day inpatient mental health program. But the prosecution, not buying it. They bring receipts from her past failures and argue she's manipulating the system again. Then we shift gears, fast. Multiple defendants, back-to-back rulings, and an emotionally charged murder case involving a competency evaluation. Oh, and one defendant faces a sex offender registry for indecency with a child. Will justice lean towards second chances or accountability? Stick around as we break down each twist with expert commentary, legal clarity, and some jaw-dropping truths you might have missed.
Mr. Nix has filed a motion asking that I reconsider that. I have asked probation for kind of an update in their response to that, as well as the state.
Here's where things get nuanced. The defense is arguing that Michelle's recent violations, missing curfews, seeking drugs, drinking, are all downstream effects of a major medication change, from Seroquel to Prozac. If true, this shifts the narrative from willful disobedience to a mental health crisis. Legally, this introduces a mitigating factor that the court must weigh. Did her actions stem from impaired judgment due to prescribed medication? But here, the problem: Prozac didn't just cause mild discomfort. The defense claims ongoing serious issues, yet she's still taking it in jail. Why hasn't that been adjusted sooner? What do you think? Does this sound like a compelling argument for rehab or just a strategic stall?
Spoke to Baptist hospitals. I have her mother and I have her fiance here. We have documentation that she would be accepted into inpatient at Baptist Hospital. I also have a letter from her doctor.
But that's just a 5 to 7 days.
No, they can actually keep her inpatient for up to 30 days, Judge, and then they have an outpatient program that could continue after that. If I could present this is a letter from her doctor that kind of underlines her very exacerbated issues. What I'm asking the court to do is not to exactly undo the SAFE-P. What I'm asking the court to do is hold the SAFE-P in a...
This is a pivotal moment. The defense isn't saying don't punish her. They're asking for delay and evaluation. They're essentially proposing a deal. Let Michelle undergo 30 days in a Baptist inpatient facility, then reassess whether she really needs SAFEP, a strict substance abuse program run by the state. It's framed as a compassionate compromise. But legally, this request puts the judge in a tight spot. If Michelle's mental health genuinely deteriorated because of a prescribed treatment, the court could risk punishing someone for being sick, not malicious. But is she trustworthy enough to follow through this time? Here's the big legal takeaway. Probation isn't unconditional freedom, it's a contract. And Michelle may be at the edge of breaking hers. Again.
At this point, we understand that SAFE-P is also a blessing. She could have been sentenced to state jail time. We're not underscoring the issues. We're explaining to the court that this is a mental health issue caused by a major medication change that's documented. Her issues follow immediately after this, and she's still on the Prozac, and she's still having lots of problems in the jail on the Prozac. We're asking that we just hold this in abeyance. I'm not asking the court to undo it, take it away, put her back on regular probation. I'm not asking for that. I'm asking to hold it in abeyance, place her, allow her to be placed in the inpatient.
But we don't, do we know, is it up to the hospital how long she stays?
I believe so, Your
I can't
Honor.
order some
Correct.
certain amount of
Correct.
time.
And however long that is, if the court feels that it's not long enough, we can reconvene and I can show you the records at that point and we can make a decision from there. But Baptist has told the family that it would be up to 30 days and then they have an outpatient treatment that can continue after that. Now, of course, we won't know if that's appropriate until we see how she does in there, but...
And boom, here, the prosecution's mic drop. Michelle's already played this card before. Back in 2022, she skipped state-ordered treatment and opted for private inpatient care in Houston, which she failed. It's déjà vu. The state argues that giving her the reins again is like handing the keys back to a reckless driver. Their point: you can't rehab if you refuse to follow the plan. This is where past behavior becomes legally relevant. Courts often consider prior noncompliance when determining whether someone is capable of success outside incarceration. So here's the real question.
I don't think
Does
it's contained in
everyone
the evidence. I
deserve
think
a
the
second
jury's gonna testify to
chance?
that, Your Honor, if you want more detail. He informed me about that this morning.
Okay. Do you have any disagreement with regard to what happened at the beginning of probation that they're talking about, Mr. Nix?
I'm not sure that I was a part
were a part
of that, so I don't know that I can speak to that. What I can speak to is that they made a major medication change that immediately caused
Judge
these
makes her
issues.
call, and it's firm.
Safety is a wonderful
Michelle is
program
headed
that's
to
helped a lot
special
of
needs
people. I don't know that
SAFEP,
it's,
not private inpatient care.
fine-tuned for her mental
Why?
health issues
Because
that are
this
causing
facility
the issues
addresses
right now.
both mental
I
health
think
and
it's a
substance
fantastic
abuse,
program,
making
and
it
I
a
still
better
think she
fit
might
than a
end up
loosely
there, but I
structured
think
private
if we get her
program.
the right mental health treatment,
Not
get her
only
on the
that,
right
the
medication,
judge
she's
also
much more
extends her
likely to be
probation
successful
by
in
2 more
safety
years.
if she has the
This
right
is a
medication and
strategic
she is
legal
of the
move.
right frame of mind.
It gives the system
The
enough
special
time
needs
to monitor
safety
compliance,
facility, do they
offer rehab,
adjust
and still have
medications and things like that?
accountability leverage.
Yeah. I think
You can
based
almost
on
hear
what
the
I know now
subtext.
from
I
the
gave you the
beginning
chance.
that
You blew
we
it.
ordered,
Now
I
you
ordered
follow
or
our
agreed or
rules.
whatever happened with
Sound off in the
ISF and then
comments.
agreed
Was this fair?
to
Would
allow
you
her
have
not
made
to
the
do
same
what
ruling?
everybody else thought was appropriate, go to our own choice, and successfully discharged from that, and here we are having the same problem. So I'm not going to adjust that order.
Yes, ma'am.
I am going to order the special needs. It's special needs safety. It's not the regular one. It is, the whole purpose of it is to treat both things. And so that can all take place there, and I think that would be better for her and for our community. In addition, I am going to, because of the issues in the administrative hearing, the fact that a motion hasn't been filed, the length of time, I think, obviously is an issue. And so I am going to also at this time order that Ms. LaChasse's probation be extended by 2 years. That should give plenty of time to get through the program, get through aftercare, make sure everything is going like it should be, and then hopefully get off this probation without a conviction or going to state jail. All right, I know it's not what you want. I hope you take advantage of it, however. It's a good program. You can talk to them about medications and get stabilized before you get out and get on aftercare. Okay, thank you, Mr.
Thank you,
Nix.
Judge.
Thank you,
Thank you,
Your
Mr. Ruiz, for being here as well. Good morning, ma'am. Are you Ebony Broussard?
Next up, Ebony Broussard, facing revocation of probation for some heavy charges: assault on a peace officer, escape while arrested, and drug possession. That's not light stuff, but instead of a direct ruling, we get a legal pause, a 2-week reset. Why? Because the defense promises she'll pay what she owes via family support. But here's the tension. She's had that chance before. The prosecutor's warning is loud and clear. If she doesn't pay, they'll proceed with revocation and possible incarceration. This is a textbook example of probation being a tightrope. One misstep, financial or behavioral, and the safety net disappears.
Smallfino.
Judge, I have spoken at length with Ms. Johnson, who has worked with this defendant for a long time now. Of course, respect her position ultimately in that she is the one who actually works with her. There are quite a bit of arrears due in this case. Ms. Broussard has been ordered previously to pay those with forms of income such as her tax return, etc. She has been defiant in doing that to the probation department. Mr. Nix indicates that she, via her family while she remains in custody, is able to do that in the next 2 weeks, and I'd like to reconvene at that time to maybe see where we are. Our position in the alternative would probably be ISF cognitive. In fact, if she does not get that paid, we may just go ahead and proceed with the motion. We'll be ready to do it on that day.
Okay, sounds good. Thank you for being here, Ms. Johnson. We'll reset the case for 2 weeks.
Thank you, Judge.
Thank you. Oh, no, no one asked. Okay, I'm just making sure. Was that one, the one that just left? Okay. Good morning. Are you Terry Rose?
Yes, ma'am.
And Mr. Rose, in cause number 241369, is charged with the offense of murder.
Now this one's chilling. Terry Rose is charged with murder, and today's hearing is about whether he's even competent to stand trial. The legal bar for competency. It's not whether he's mentally healthy, just whether he understands the proceedings and can aid in his defense. A court-appointed evaluator says yes, he's competent. That finding activates the next phase, trial prep. Prosecutors are ready. Defense is requesting 45 days to get their investigator up to speed. This isn't courtroom drama, it's real life. And behind every motion is a grieving family waiting for justice.
Any issue with that, Mr. Nichols?
No, Your Honor, we're just, state's ready to proceed.
And I appreciate you getting up to speed as quickly as possible. Looks like we've got an investigator involved and you've taken care of that.
We do,
So
and I was out, I provided him information, and he's helping me with this, and so once I cover all my bases and get up to see the district attorney, we'll be able to take care of this now.
all right, what I'll do to make sure your investigator, and you have plenty of time to get up to speed, is reset it 45 days and expect an announcement on that date.
Thank you.
All right?
Maybe
Thank you.
excuse to that time.
Yes, sir.
Thank you, Judge.
They print out the ones that are being, just the 4 that he's pleading on. I need,
Got these right here, if that's what you need.
everything, all of them except 0534. Good morning. Are you Bryce Thomas?
It's not good.
And Mr. Burbank, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor, we're going open on each case, and the aggravated sexual assault is being the lesser included indecency by exposure, which is a third degree.
So is,
Did you sign it? Did not.
we can do it, y'all can get it done as soon as I'm finished. I'll go,
Completely about the registration.
I'll just go through it with them. I just want to make sure, because of the agreement for the lesser in that case and for anything to run concurrently, is that the plea bargain agreement where he would be waiving his right to appeal?
And also, they're
The dismissal.
dismissing the UUMB.
Gotcha, okay. Give me just a second, yeah.
And the lesser included is instead of a first, is a
Third. Oh, 0354's been dismissed, I think. Or 0534, whatever I said. Okay, Mr. Thomas, in cause number 24, DCCR 0389, you're charged with a third-degree felony offense of possession of a prohibited weapon from January 31st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In cause number 240390, you're charged with a third-degree felony offense of possession of a prohibited weapon from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In cause number 24 DCCR 0391, you're charged with a state jail felony offense of theft of a firearm, and that's from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then what is the reduction to?
It's indecency exposure, third-degree felony.
In cause number 24, DCCR 0392, the state has elected to proceed on the lesser included offense of a third-degree felony of indecency with a child by exposure. And that's from November 9th of 2023. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them? And I want to make sure you understand there's kind of a partial agreement, and that agreement is that the state is going to dismiss cause number 240534, which is an unauthorized use of a vehicle. They are agreeing to that lesser included offense of the indecency in that case. And they're also agreeing that if anything that I sentence you to, if it's time in prison, would run concurrently. There's not a specific agreement with regard to any time or any outcome, only those agreements with regard to the dismissal of the case, the reduction in the other case, and the fact that they'll all run at the same time. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
And there you have it. 1 courtroom, 4 cases, and a whirlwind of legal strategy, second chances, and life-altering rulings. Michelle Laws walks away with an extended probation and mandatory SAFEP. Ebony Broussard gets 2 weeks to fix her finances or face the consequences. Terry Rose, facing murder charges, is now officially competent for trial. And Bryce Thomas, a string of guilty pleas, a plea deal, and a looming sex offender registration. In every one of these stories, the courtroom isn't just a setting, it's a stage where lives pivot. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. This is Courtroom Chronicles, where real justice gets real.